It's time to require lobbyists to disclose each contact they make on behalf of a client with my administration or with Congress. It's time to put strict limits on the contributions that lobbyists give to candidates for federal office. With all due deference to separation of powers, last week the Supreme Court reversed a century of law that I believe will open the floodgates for special interests, including foreign corporations, to spend without limit in our elections.
Chair now recognizes himself for 5 minutes. You undoubtedly saw that clip when it was fresher, I suspect. It's clear that the President believes that the unlimited right of free speech is not appropriately decided, and he made that clear. Do you believe that free speech is, in fact, a right that relies to a certain extent on privacy of how money is spent?
Mr. Chairman, I'm going to get a bit out of my depth when I go beyond the procurement system.
Well, let's put it another way. Do you believe the government has a legitimate right to know whether I gave to the pro-life movement, whether I gave to United Gays and Lesbians, or whether I gave to the Democratic Party if I am a vendor of the government submitting a bid?
I don't feel comfortable addressing the issue of campaign finance disclosure.
It's not campaign finance disclosure. It's political activity not currently covered by the disclosure, which ultimately we're not going to be endlessly asking you questions about the specifics of that. But the broad question is, do you believe that that is necessary information in order for a nonpartisan or a partisan appointee to participate fairly in the procurement? In your opening statement, you made it very clear. You said it's supposed to be only in the structured requirement. Have you ever sent one out? Have you ever sent out a bid request that asked how much you gave to United Gay and Lesbian organizations or to the National Right to Life or any of these? Has that ever been part of the procurement process?
No, sir. I would not expect that to be an evaluation criterion at any point in the future, just as it has not been in the past.
So if I read you correctly, and I want to be very careful, you don't see that as necessary information in the procurement process?
In the selection of a contractor, a contractor can only be selected based on the factors that are set out in the solicitation. If the question is, would the public like to know what contributions are made, that's separate from the procurement process itself.
Okay. So in looking at the draft executive order, we found that it would be a requirement in order to participate in the contracting process. Do you believe, not talking to the executive order, but do you believe that we have a right to ask for information completely unrelated to the fitness of a vendor in order to give information to the public that would not otherwise be available simply because somebody wants to be a vendor to the government?
There are many sorts of information that we require vendors to submit. Information about lobbying, for example. It is not taken into account in the selection of contractors, but it's required to be submitted and it is publicly available. There are other examples I could give you of information that we believe the public should have access to, even though they're not taken into account in the award of a contract.
So where is the constitutional charge of the President, without an act of Congress, to in fact require private citizens to turn over information in order to enter into the flow of commerce? I don't want to know about historic things that nobody argued about. We're now talking about Chicago hardball politics that clearly could lead to a chilling effect on contributions by those required to participate. Clearly, unions are exempt from this draft order, while corporations generally are not, and their key employees. Where is the authority, in your opinion, or the need? You've already said there isn't a need. Where is the authority, in your opinion?
Mr. Chairman, you won't be surprised to hear that I'm not a constitutional lawyer and I won't be citing to the Constitution.
So you head up the procurement. You are the responsible party at OMB. You see no need. So therefore, if this executive order or one substantially similar were to happen, it would not be based on need. it would probably be based on the President's statement at the State of the Union and his opinion that follows that, obviously.
I don't understand your reference to need. Let me be clear. What I was saying was in the selection of the contractor, the winning competitor for the contract, the information about political contributions is not needed. That's
okay. So the executive order, as we read it, is asking for information that's not needed
to decide which company should receive a contract. That's
okay. So you're asking for unneeded information. Do you believe that people may choose not to make contributions if they're forced to make, for example, known that they gave to Planned Parenthood or National Right to Life?
Sir, you're outside the area where I feel comfortable expressing a view.
Well, I think it's very clear. This executive order is outside the procurement process. And with that, I recognize the ranking